we've been talking about one of the things, the name, image, likeness that is just crashing down on college athletics, unfortunately, because the NCAA has kept their head in the sand for too long, and now they're in the 11th hour, and you've got state laws that are going into effect, a failed attempt at getting a federal legislation passed, and now several groups are saying no, they don't want what the NCAA is proposing. They want to let the schools or the conferences to do it, and they're in the 11th hour, man, and they're sitting there spinning. I don't know how in the world they're going to get this done with these other states that are already set to go in effect in less than like 10 days.
I think it's going to be impossible, probably. I think it's not the most important point, but an important point to start with is they've had a decade to get this right. The O'Bannon case that really kicked this off, that lawsuit got filed 12 years ago. And, everyone has seen what's coming. And the NCAA just, I think, like you said, buried their head in the sand and pretended that, that they were above the law, and could do whatever they wanted with these athletes. And they're learning, learned yesterday in another way in the Alston case, they're learning that that's not the case. And it is going to create a mess. 6 states have laws that go into effect next week on July 1st. And those, the schools in those states, it creates an issue for really 2 different parties. If we're talking about the schools, one, the schools that are in states that don't have these laws and are, stuck abiding by the NCAA's rules, they're going to be at a disadvantage when it comes to recruiting, you would assume. And beyond that, these schools in these states that these laws are about to start, they have 2 choices, or 2 options, but they really don't have a choice to make here. They either have to violate the law of their state, or they have to breach the contract that they've signed with the NCAA to abide by the NCAA's rules. And so it's really, for Alabama is one of the states, that I believe that goes into effect next week. So Alabama and Auburn football players, what does the school do? Do they say we're going to disobey the state legislature and the governor? We're not going to abide by this, and you can't go out and get a deal with Nike or the car dealership down the road? Or are they going to say, sorry, but the government told us that this is what we have to do, and Mark Emmert, you're not in charge of this anymore?
And now we've got the schools that are in states that don't have any kind of legislation in effect. They can't go out on their own, or can they yet do this?
Not without breaching the NCAA's rules. And I mean, I think a lot of your Indiana basketball fans are well aware of the things that happen when you do that. And, just let's talk about Indiana specifically for a minute. Ross Dellinger with Sports Illustrated had an article out this morning that had a map that was really helpful to show, which 6 states are going into effect, which states have pending legislation, which states introduced legislation in 2021, and which states, have nothing. And Indiana is surrounded by states that have introduced legislation. Illinois has a bill in front of the governor right now, and it's not hard to imagine a scenario where it does put you at a competitive disadvantage as a school if your legislature doesn't step up and follow suit, or if the NCAA Division I Council doesn't get it together this week before July 1st. Let's think about Eric Gordon, for example. If Illinois signs this bill and Eric Gordon's recruitment was happening now, you think he's as likely to flip if he can go ahead and sign with Nike or Adidas or do commercials for somebody in Champaign? Or is he still going to come to Bloomington where all he's going to get is the academic cost, which admittedly went up yesterday with the Alston case? But, it seems like, particularly with Power 5 schools, that if you're in a league that have schools in other states that have passed these things, you're going to be at a real disadvantage if you haven't. And my assumption is that Indiana will be one of the last schools to follow suit if the NCAA doesn't come out and do something, and the courts don't make a ruling of some kind because of the relationship that the state has with the NCAA. I think that it's only fair to assume that that's the reason that Indiana is one of just a handful of states that hasn't even introduced a bill on NIL.
I think that's part of it. Also, Indiana is not exactly a progressive state. I mean, you look at things like marijuana is the same type of thing. You got Illinois, Michigan, all the states that are around them, which I know it's different, but it's a conservative state, and they just don't move on things until they're absolutely forced to, it seems.
Yeah, I think that's part of it as well. You can make the same arguments for Alabama. One of the states that's implementing this next week, but you also can make the argument that there's nothing more important to those people than Alabama football or Auburn football, and they weren't going to get left behind once California really kind of started the ball rolling on this.
I'm surprised that. Go ahead, Kevin.
I was going to ask Alex, if a player from the state of Florida goes to school at the University of Indiana, does that player from Florida?
Whoa, Kevin, stop yourself right there. You cannot make that mistake. That mistake can never be allowed to happen here.
Yeah.
Indiana University, please. Thank you very much.
Indiana University, rather.
There you go.
Indiana University. No, I was just curious about economic. I was just curious about economic rights. Do the rights of the player come from the state, or do they come from the institution?
So my understanding is that with the NIL things, that it's going to come with the state where the athlete is performing. We're competing. It basically would act just like state income tax laws would.
Pro sports, those guys, if they live in California,
right,
but they play for New York, they've got to pay both taxes, I think, right?
Yep. Yeah. So, it's don't hold me to that, but that's my best understanding is that, if you were, or take it vice versa, if you were an Indiana athlete and went to Florida, you would still have the NIL rights that Florida's about to enact. You come from there to here, though, not going to be the case.
The one thing is, Indiana is not alone. There are tons of states that are in this position. So there's no way that I can see these states and schools saying, hey, we can't compete at this disadvantage. So they're going to have to do something and do it fast. But what happens usually when you do something this big, this fast, mistakes are made and things are missed.
Yeah. And I think the NCAA is, Mark Emmert had that leaked email or memo that was sent to the schools that said, get ready for NIL because it's coming. But they have to be glad that not every state has gone out there yet and done anything, because it's going to give them an opportunity to do what they did in the 90s in the Miller case. You may recall that UNLV had an issue with the NCAA's treatment of Jerry Tarkanian and enacted a law that basically prohibited the NCAA from punishing state employees or something of that nature. And UNLV sued, and the law, or the NCAA sued the state of Nevada. The law was actually struck down based on the grounds that they couldn't pass a law that breached the way the NCAA could contract with other actors, that it was an impediment to their freedom to contract. And I think the NCAA is going to make two arguments if these things end up in court. They're going to make the same kind of argument that these state legislatures are impeding on their ability to contract with their member institutions by creating a rule that runs afoul of how they want to contract and how they already have contracted with them. And second, they're going to make an argument based on the Commerce Clause of the Constitution, which says that Congress has the authority to regulate commerce among the states. And what it means is between the states. So anything that's interstate commerce, Congress has the ability and the authority to regulate. States do not. And so if Congress doesn't pass an NIL law, and I think we've seen that ship has sailed. They tried, they couldn't get it done, couldn't get anything out of committee. If Congress doesn't do it, the NCAA, I think their best argument is to go to the courts, to the federal courts, and say, look, all these states have different laws, and it's making us, and really anybody who ever wants to be like us, it's making it impossible for us to put on these competitions and run this business that does operate in 49 or 50 states. And that's going to be their best argument moving forward. So I think that practically the best thing would be for the Division One Council, who I believe is meeting today and tomorrow, to do what they should have done in January and pass a rule. And at this point, they probably need to pass a rule that matches whatever is the most liberal application of the NIL laws out there right now, presumably the California law, and then let everyone know that that's the rule starting July 1st. But in the alternative, if they decide that they want to, they want to be headstrong about it and fight like they did in the Alston case, then, I don't think that there's any question that if they decide to fight the states on this, that this is headed to the Supreme Court, and we'll have, another opinion like the one yesterday on college athletics.